All right, thank you for tuning in. I'm trying to get the camera set here. John Fuller is in the studio, and we are ready to begin his program. This is called Legally Yours. Thank you, music. And he's here to answer your questions about the law. The phone number, if you'd like to call in, is the WOCA Climate Control Source Hotline, 622-9622. I'm still getting used to these buttons here over here, John. John is with the law firm of Fuller and Fuller, of course. I think you all knew that already. The other Fuller is Janet, and I will tell you the location and the phone number for his practice. But first, let's just say good morning to John. Good morning.
Good morning, Larry. Good morning to our listeners. It's a beautiful Wednesday day, and we're happy to be here live with you. Janet is at our office in the Villages seeing clients all morning on Social Security disability cases that she has for them down there. And I'm real happy to be here with you and our radio audience who may have issues concerning our legal system, or they may have a question about a legal matter that affects them or their family or someone they're close to. We're very happy to talk about those things that we deal with in our practice, and that's litigation matters, Social Security disability, commercial business litigation, or if you're injured in a serious accident, that sort of thing, or in a very limited manner, complex family law matters. We do those if they have like a business component in it or something like that. So if folks have specific needs, we're happy to see them at the office, but this program is a chance to give us an opportunity to have a general dialogue, because there's not anything in our society that we do that we don't generally have some interaction with a rule, a regulation, a law, or the legal system in some fashion.
Right. We just had a forensic anthropologist on, the lady I was just talking to about, the lady who wrote that Bones book. And I have a question for you in the legal system regarding what somebody like that would do. If somebody was shot and killed and a forensic scientist looked at the body and was to determine something, does a lawyer have the right, I don't know if right is the right word, but the tools to withhold, to cause that information to be withheld from the jury being familiar with it?
Well, the rules of evidence determine what evidence a jury ultimately hears. So a judge would make a determination as to whether or not certain scientific evidence met the requirements. There have been two standards. There have been some recent law to try to merge them in Florida with the federal case. There are two cases, the Fry case and the Dolbear case. One of the standards, which was the more lenient standard that Florida has had for years, is that it just simply met generally acceptable scientific standards. The federal standard has been more stringent. Florida has had a movement to adopt the federal standard, and that would require that the judge serve as the gatekeeper to determine the reliability of the forensic testimony. One of the things that this raises a very interesting point, and lawyers in trying cases utilize expert witnesses as one of their most important tools to help explain and answer questions to get to the truth of the matter. These professionals are forensic experts. They're forensic pharmacologists, they're forensic engineers, they're forensic pathologists, and as you mentioned from your previous guest, a forensic anthropologist. The admissibility of the evidence is ultimately determined by the judge. The challenge to that is often brought to the court's attention by a pretrial motion, where the court hears this evidence without the jury being present and here's what is the scientific basis, and it is based upon the scientific principle, whether or not it has been generally accepted in the scientific community, or is this an expert who has developed some theory that is his, and then it must be measured as to whether or not it rises to that level of generally accepted scientific evidence. It is very important. We use, in cases I've tried involving DUI manslaughter, I've used forensic chemists, forensic toxicologists, forensic pathologists, and forensic pharmacologists, all to address the dynamics of the absorption and dissipation of the rate of ethyl alcohol in the body, and the time frame for that, and the impact that it would have on one's mental faculties. Yes.
So the number that is the number that is shown on the device that the police officer gives right after the fact when they take the breathalyzer test, that in and of itself can actually be contested?
Oh, well, that's a huge part of the trial. The first thing, and I think everybody will agree on this, that the results from an intoxilyzer breath test is secondary extrapolation at best, because what you want to know is what is the blood alcohol level. Well, obviously the best test for that is a blood test with the blood specimen put through a gas chromatograph, which breaks down the different ethyls and components in the blood to determine what is the concentration of ethyl alcohol. That's the gold standard. When you blow in a tube, what this machine is doing is it is set up so that it is converting your deep lung air, it's called alveolar air, and they make a presumption that the concentration of blood that's in the deep lung air is 2,100 to 1 of the concentration of what it would be in a specimen of blood if they had done it.
Okay.
Well, we all know that when you take generalities, what your ratio may be as someone who is a man your size may be different than, say, a female who weighs 90 pounds.
Right.
But the law creates this legal fiction that we all have a 2,100 to 1 ratio, and that's what the machine is set up on. Other ways of challenging that is this machine, and the people who use it don't like me calling it a machine. They like to refer to it as an instrument.
Okay.
So they can call it an instrument. I call it a machine. It is a mechanical device, and they only have to calibrate that and do the test and the purge on it once a month. That doesn't mean on the same day every month. It means once every calendar month. So they could do it on June 1st, okay, and then they could do it on July 30th. That's almost a 60-day window.
Right.
And that in and of itself, I think, creates a reasonable doubt as to the reliability of it. The intoxilyzer machine in and of itself is generally a reliable instrument, okay? It is used by legitimate scientists, and I am not saying that it doesn't have accurate results if it is accurately calibrated. And let me just pose a question to you that I would pose to a jury in closing argument. If you were going to a doctor with a serious, potentially serious health question, and that doctor was going to use an instrument to diagnose what your potentially serious condition was, Would you like him to use an instrument that was calibrated just before he did the test on you, or one that had been calibrated 60 days ago?
Yeah, good point. Of course you want the one that was recently.
And they don't have the money or the resources to calibrate this instrument on each time they do a blow. There are other things that can cause it to have false positives. For instance, if you burp or belch or regurgitate stomach fluids into your mouth,
right,
and then you blow into the tube within 20 or 30 minutes of having done that, if you have had an alcoholic beverage, it's in your stomach. It's not in your blood. They want to test the air and then use the extrapolation to determine the level of the blood.
Sense, yeah.
But what they're getting are the alcohol fumes from your stomach content, and that gives an artificially high. So, yes, there are many, many, many ways to attack the validity of a chemical breath test. There are ways to attack the viability of the gas chromatograph, but it is much more difficult because it is a much more sophisticated, much more precise, much more reliable scientific instrument, and it is considered the gold standard. And that's not just on alcohol, that's on any kind of drug content.
Oh, really?
Yes, right.
By the way, the broadcast you're listening to right now is happening on Wednesday, August 28th, 2013. I mentioned the dates so that you as a listener will know whether it's a live show or not. John isn't always able to do these shows live because he does do his work in the courtroom sometimes, and they don't really look at it too kindly when you say, I got to go do a radio show.
When you have a court appearance, absent being severely ill, or having a conflict where you have to be in another court, and they have rules to determine which court takes precedence, you have to be there. That's a definite. So radio shows, as much as I enjoy doing them, that would be bumped. But I'm delighted to be here today.
So I'm inviting the listeners to call if they have a question for you. The number is the WOCA Climate Control Source Hotline, 622-WOCA. So one more question about the DUI scenario. You always see the dashboard cam. You always see, well, now and then you see the officer saying, walk a straight line or touch your nose and all that stuff. I don't drink, but I think I would fail at that test, that walk the straight line test. I think I would lose my balance. I'd be nervous or something, or the touch the nose. I think I'd hit my eye or something. I don't know.
Yeah. Well, those things are certainly subjective. One of the things that they are doing better now is they have, if most of the patrol cars, they have video cameras, and they have a video camera at the jail so you could see someone doing it. However, as you just alluded to, there are many explanations as to why someone may physically not be able to perform these, what they call field sobriety exercises, which are designed to test your coordination and control of your normal faculties because of physical illness. Some people have middle ear infections, which would cause you to have some vertigo from dizziness if you have an ear infection. Some people have injuries, chronic injuries to their feet or lower extremities that prevent them from being able to be full weight bearing, much less full weight bearing while they're trying to walk heel to toe 8 steps out, make a 180 and come back. So there's a lot of challenges to those, and other explanations that could be made is like, okay, I was unable to perform that, but here's the reason why.
Yeah, right. And
it had nothing to do with me being intoxicated. It's I've got a broken knee.
Or I'm just uncoordinated. All right, let's go to the phone. John Fuller is your host. Good morning. You're on the air with John.
Yes, good morning, Mr. Fuller.
Hey, how are you today?
Very good, thank you. I've always wondered, when a person receives the death sentence, the death penalty, has it always been in the past it takes so long before that is actually carried out? My feeling is, let's say a fellow of middle age, let's say 65 or maybe even 70, and gets the death penalty, and they know right right away that the guy, he's probably got 20 years before he faces that death penalty, because it goes through all kinds of whatever to see if he can get out of it or not. And by that time, the guy is probably close to death anyways. Is there any way that could be speeded up, or has it always been that way with the new laws that have come in play later on here? Is that why it takes such a long time for that procedure to be executed?
Well, there's a lot of interesting points that you raise. You always have such good questions, and thank you for calling. First of all, let's start out with the premise as to what is the goal of our criminal justice system. And former Judge Raymond McNeil, who's one of the outstanding judges in Florida, who was a circuit judge here for 30 years or so, when he was on the criminal bench, I heard him tell juries as trials took a long period of time, just at the trial level. And he said our system of justice, especially when you're dealing with the question of life and death, which is the ultimate finality in the criminal justice system, is designed insofar as is humanly possible with a human institution to get it right. It's more important to get it right than to get it done quickly. So, yes, have there been inordinate delays and abuses in the system? Without question. They are laws afoot, and the judge has signed one bill not too long ago, I think. The governor signed a bill not too long ago to try to expedite that, and the courts are determining the constitutionality of that now. I would only remind you, as you look at this time frame with some degree of frustration, to go on to the internet, go to Google the Innocence Project, and you will be shocked by the number of people who have been convicted and sentenced to death and were serving time on death row, and they were completely exonerated by DNA evidence that proved unequivocally that they were not guilty. Had there been a rush to execution without the chance for the judicial system to have appeals, to have it reviewed, some of these people who are getting out of jail, they didn't have DNA when they were sentenced. But they are now determining that the number is shocking. Yeah. And so while it is certainly frustrating, and I empathize with the victims of crime, especially a death sentence type situation, we still operate on the premise that it is better that someone who may be guilty go free than someone who may be innocent is put to death, because death is final. And once the lethal injection is given, and then they find out that the evidence that led to the conviction was fatally flawed, you don't have a do-over in the death sentence.
Yeah. Let's give you a scenario here. Let's say a person is okay. He's got the death sentence, or her, and he admits that he did whatever he did to put him in that situation, and does not want to spend any time in jail and wants to be put to sleep. Can they request that, and would that be speeded up?
The courts have a duty to see that due process is carried out, because there are many questions of people who may be legally competent to stand trial, may not meet the legal criteria for insanity, but who are still mentally impaired in some form or fashion. So as a matter of our general concept of due process of law, the court wants to assure that everyone has a fair trial, especially before enacting that, even if the person comes in and pleads, if a person wants to plead guilty to it, even that is something that is looked at very, very, very carefully, because one of the questions is, did they have adequate assistance of counsel? And some people have, for better or worse, a death wish. And the state of Florida is not a partner to being a Dr. Kevorkian for someone who may have emotional problems, wanting to use the criminal justice system for death by trial simply because of other mental illnesses. So the court system has a dual duty to see that there is a fair trial and that there is competent evidence before it would go to something as extreme as the death penalty.
Okay, well, thank you very much. Very good answers.
Thank you for calling.
Very interesting subject. Yeah, thank you.
It is indeed. It's a very complex subject, and there are very strong feelings on it on both sides. There's a lot of argument on whether or not it's appropriate to have the death penalty. If we do, how to apply it. I see people's point of view on both sides.
And right now in the news, the Michael Bargo story with I guess the jury came back 10-2 for the death penalty, and now it's in the judge's hands. So the judge could, I mean, it's up to him now. What a place to be in. I feel for the judge. What a weight.
Judges have our judges, all judges, it's a difficult job, especially in a criminal case. The jury recommendation is not binding on the judge. The judge will make the ultimate determination. It is persuasive but not binding. Interestingly enough, and I have not followed that case at all, just been busy and haven't read it and haven't followed it. Many states require that you have a unanimous verdict in the penalty phase in order to make the recommendation. In other words, if you don't have 12 out of 12 to recommend death, then there is no recommendation for death. A lot of states have that. There's a movement afoot in Florida to adopt that too. We have to have a unanimous verdict in our jury to determine guilt or innocence. And in the penalty phase, it doesn't have to be unanimous. It just has to be a majority. So there's some movement afoot to revisit as to whether or not, when a jury is going to be making a recommendation in the penalty phase as to whether or not there should be a death by lethal injection or life imprisonment, that recommendation has to be unanimous.
And you have another phone call. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller.
Good morning. How are you, sir? It's good to hear from you.
Always good listening to your
Thank you.
Explanations, especially in regards to the death penalty. I'm always amazed at the number of people in the state of Texas and Florida, incidentally the southern states, that always have a high rate of death penalties. The question that I have is, I see where Mr. George Zimmerman has his attorney said that they're going to ask the state to reimburse them for the legal fees. However, the attorney talks about around $200,000, and I understand he raised about $300,000 from various donors. My question is, what are the chances of him being reimbursed by the state since he was found not guilty? And the other thing is, what happens with the money that he got from the donors? I'll hang up and listen to and you have a good week.
Thank you so much for your call. Let me say about three things first on it. I agree with you that it's very peculiar that Texas and Florida have more people on death row than any other states in the union that I know of. I may not be correct in that, but I believe you made that comment, and I believe you are right. Another thing that troubles me greatly is that the majority of those people that are on death row are members of minorities, and I think that is unacceptable, and that offends me, and I would like to see that addressed and that reversed. I have not read the details of the latest stuff in the Zimmerman case. I can tell you from having been involved in very major protracted lawsuits that even though there may have been a trust fund where they raised $300,000, $300,000, believe it or not, would not be adequate to pay all of the fees, costs, and expenses for the Zimmerman trial defense team. Now, getting to this application for the state to have to reimburse Zimmerman some monies. I didn't read it. I don't know anything about it. I do know what the argument is, and I'm going to address it in the abstract. There's a United States Supreme Court case called Brady versus Maryland. And it says that the government, whether it's state or federal prosecutor, if they have any evidence that they know or should have known of with reasonable diligence, is exculpatory or favorable for the defendant, either on the issue of guilt or innocence, and they do not give that information to the defendant after it is requested, they then, if there's a conviction, there will be a reversal. In this case, from what I recall reading, there was a computer expert working with the state who was a whistleblower, who said that the prosecution had thousands of documents of records that were exculpatory of Mr. Zimmerman, or could have been reasonably interpreted as exculpatory of Mr. Zimmerman, and they failed to give that to the defense until the defense found out about it, called this individual from the state attorney's office who had located it and went public with it, had him testify to the judge. The judge ordered them to give it to them. The judge denied their motion for a continuance so they would have time to review this, and they received thousands of documents at the last minute and had to hire additional manpower to be able to review, analyze, and prepare for trial with this last-minute dump of documents that the government had allegedly been sitting on and knew about. And then after this person came forward and the whistleblower, and right after the trial was over, the prosecuting attorney fired him.
Wow.
That was on television. So the law provides, the judge ruled that she was not going to give them a continuance, and they asked for sanctions. And the sanctions, the punishment for the prosecutor for failing to timely give this vast amount of information to them and creating such unnecessary, extraordinary 11th hour work, was a sanction to make the state of Florida pay them the additional funds that they incurred because they had to go hire additional paralegals and additional experts and additional attorneys to come in and help go through documents that the state knew that they had, that the defense had asked for.
Right.
And that the defense and that the state had, according to the defense allegation, willfully failed to disclose it to them. That's what the judge is going to be asked to rule on. The judge reserved ruling on that and said she would take it up at a sanction hearing after the case was over. I don't know whether that's been heard or not, but that grows out of a Supreme Court case, Brady versus Maryland.
Wow. Fascinating stuff. John, how do we get a hold of you if we need you to help us? Okay.
Our office in Ocala is 352-547-4292. Our toll-free number is 855-534-2565. we have offices here in Ocala and the Villages, and if we can help you with a legal problem that's in our area of practice, please don't hesitate to call.
And don't hesitate to call us either if you need that information repeated over the phone, or if you go to the WOCA.com website and look at the guest list for AM Ocala Live, you'll see Legally Yours listed at 10:35 every Wednesday, and Robin keeps it up to date, and the phone numbers are right there. John Fuller, always good to see you.
Thank you. Always a pleasure. Thanks to our callers. They are very loyal listeners. They always have great questions. They stay up with the current events, and questions like that are what hopefully makes this program interesting.
And we all want to know the answers. All right, we'll take a little break and be right back.
Ocala's information station, 1370 WOCA.